this point, and do other folks see images, or are you seeing dots?
I'm seeing images, Judge, but I'm getting an echo.
I'm getting a terrible echo. That's why I ask, please mute yourselves right now. And if the attorneys who are arguing the case would please go ahead and turn their cameras on so that we can see you. All right, so I can see, how do you pronounce your name? Kelly?
Okay,
You're muted, sorry.
Judge, I think I see the problem. There are two Jeffrey Victors. One is not on a mic mute, and so my guess is in that room you have sort of ping pong going back and forth with Victor, wherever that on that computer. There are two separate ones. One's muted now, one's not. That's why.
Yeah, that's where the feedback loop is coming from. But I also cannot see Jeffrey Victor. All I have is a. Let me see if this one comes up with an image.
I think he might have it on, you know, not the video on.
Yeah, I need the video turned on. And then I have, and I assume those are the two folks who are arguing. Mr. Victor, can you hear us? We haven't really heard you.
I can see you, but I'm getting some severe echoing.
That's because for some reason you are in here twice. So I can see you now. I'm going to make sure which one of it is the one, and I'm going to have you removed. I apologize for.
Thank you.
All right, I believe now that should have taken care of our echo.
But yeah, now you need Mr. Victor.
I muted the wrong one. Yep.
No, you didn't. You hit the right one. But now, okay. Can you unmute one, Mr. Victor?
Dave, it's still showing two both.
Yeah, I know.
Can we kick one out?
Yeah.
I need to make sure which one is the right one to remove.
Let me see if I can.
So give me a moment.
Thank you.
If it helps, the one we want removed, I believe it starts with a small J.
Well,
on my screen.
Actually, when he spoke the last time, Mr. Victor, I didn't get an echo. Can you speak one more time?
Sure. Good morning, Your Honor. This is Jeffrey Victor.
There's still an echo there.
Okay.
All right, so I have removed the extra person. Let's start, and this is technology, don't we love it? All right, so let me start. Judge Weinsweig, let's just have you speak and see if we get an echo.
I can't hear one.
All right, I don't either. Judge Brown, do you hear an echo at this point?
I don't think so.
Mr. Victor, are you hearing an echo?
No, I'm good, Your Honor. Thank you.
Oh, much better, yes.
Yes, and then I'm going to have you tell us your name again, or pronounce it for me so I don't mispronounce it, because we had a great echo.
It's Jankaitis, and I do not hear it.
All right, so Ms. Jankaitis, I think we're good. Thank you. This is the joy of technology. This is the time set then for oral argument in 1 CV20 0371, Koskovich v. Scottsdale Healthcare et al. We are proceeding in our video conference format. One of the aspects of that is keeping track of time. I will keep track of your time. I will give you signposts to the extent I can, but I also suggest that you keep and require that you keep track of your own time. You each have 20 minutes. You do not have to use all of that time, but certainly that time is available for your use if it is necessary. What I will do is, again, give you the signpost so that you know where you're at. If you want to reserve rebuttal, that is your choice. You can advise us of it, but you're responsible for reserving your own rebuttal time. When you do stop speaking, I will tell you how much time you have left so that you are aware, and also so that I write it down. We have, please keep in mind, read the briefs. We have studied the record. I'm starting to get an echo again. We'll see if it stops. And we have discussed the case in conference. I'm going to ask, if you are not arguing, that you mute yourself. That may help us with that little bit of echo that we got. With that, counsel, you may proceed.
Good morning, Your Honors. This is Jeffrey Victor. I represent the appellant Barbara Koskovich. And if I may, Your Honors, I'd like to reserve about 4 or 5 minutes for rebuttal, please. And if I could just have a second and turn on my time clock, I'd appreciate it. Okay, thank you, Your Honors. I appreciate it. It seems like there's a little bit of an echo. Okay, maybe not. All right, Your Honors, this case is about a loss of chance doctrine that is evolves out of Section 323, the Restatement of Torts, second, and the Thompson case, the long-established case in Arizona regarding Thompson. In this particular case, in the Koskovich case, Your Honors, the trial court, in all respect, applied the wrong standard at the request of the appellee. The court applied the incorrect cause and fact standard at the request of the appellee. The appellee in the oral argument in the lower court specifically advised Judge Campanella that Thompson was a different beast, quote unquote, and that the Thompson loss of chance doctrine did not apply here. There is a clear error and abuse of discretion here.
Mr. Victor?
Yes, Your Honor.
This is Judge White, and can you hear me, or is there an echo?
Yes, I can hear you. Thank you, Judge.
Okay, so before getting to Thompson and loss of chance, I want to go way back and start at the very beginning, which is we have a question of causation. Isn't the question, but for the nurse contacting a hospitalist physician at her elbow assigned and not contacting the rapid response team, and then finish off that Donald passed away? It's not as both parties seem to present in either a rapid response call or nothing at all. I just want to settle that first of all.
Well, I think the negligence is the failure to call a rapid response, at least with regards to the loss of chance doctrine. If you don't call the rapid, go ahead.
Well, no, and we'll get to loss of chance. I'm just trying to frame, the inquiry of but for. This nurse did something. She contacted Dr. Reyes. So isn't that framing the inquiry on one side, and the other side is pulling the rapid response alarm?
She may have called Dr. Reyes earlier in the afternoon, but this gentleman, Donald Koskovich, was rapidly declining and deteriorating. And I'll go through the list of factors that she saw or should have seen over the course of the day.
Your expert gave 3 dates on October 1, as early as 6:38 a.m., at 11, or at
an hour before.
But then if you read the deposition, she commits and says, yes, my opinion is 11. Okay. And so if you look at the record, and if I'm wrong, you could tell me where this nurse at 11, after speaking to the plaintiff, contacted a hospitalist physician. So doesn't that frame the bottom rung of the inquiry? It's not a matter of whether rapid response would have been changed things compared to nobody being called. there was a hospitalist physician called. And so the causation issue and the evidence and the record evidence that must be presented is that there's a qualitative or quantitative difference between Dr. Reyes, a hospitalist physician, and the rapid response team. And that difference meant life or death.
There is a difference, and thank you for bringing that up, because Nurse Mancuso, the plaintiff's nursing expert, said there were 3 different times on the 1st of October that a rapid response should have been called by the nurse. And as early as 6:30 in the morning, 11 o'clock in the morning, when Barbara Koskovich is bedside, and she's, my words, pleading for help, asking the nurse because she sees the marked change and the deterioration in her husband. And then 1 hour before the code was at 3:45. So if the rapid response had called at 2:45, that's the last opportunity to bring a team of experts, a team of physicians, according to Nurse Mancuso. And one of the experts would have been an intensivist or a critical care doctor. And that's what Dr. Salzman is, by the way, the causation expert. Dr. Gary Salzman is a critical care doctor. And Dr. Salzman says, if an hour before they would have inserted an NG tube, a nasogastric tube, this man would have survived.
But if you want to ask, Judge Goss, okay, so, but would you agree with me, again, going all the way back to the beginning and just framing the inquiry? I'm not getting into the evidence yet, and of causation, but I'm saying this nurse did something. She contacted a hospitalist physician at 11 a.m. Isn't that the but-for inquiry?
No, she didn't do enough, in all due respect. 11 o'clock and 2:45 is a difference of 3 hours and 45 minutes. This man was deteriorating over time. And despite what Dr. Reyes did or did not do, the nurse has, if nothing else, she has the power and the authority and the duty to call a rapid response team, a team of individuals.
This nurse contacted Dr. Reyes at 11:05 or thereabouts, directly after speaking with the plaintiff here. And if you look at the expert Mancuso's deposition, she says, yes, it's 11 that it should have been called. All I'm trying to say, are we supposed to ignore what actually happened? That she contacted someone, a hospitalist physician, and is that the inquiry? Nothing versus the rapid response team?
No, that's a good question. The mere contacting of the hospitalist, Dr. Reyes, doesn't fulfill her duty, especially if she's with the patient for another 3 hours and 45 minutes and sees that he continues to deteriorate. The nurse has the option, she has the duty, she has the responsibility, despite whether the doctor's coming or not, despite what he says at 11 o'clock, to call a rapid response team. And she had that opportunity. She had that opportunity all the way up to 2:45, and it would have made a difference.
Okay, so let's now move on from I don't think standard of care, it doesn't seem like that was an issue or was at least not decided. So let's look at causation. Where in this record, let me ask you, who was on that rapid response team at that time? What are the names of the doctors?
Well, Nurse Mancuso, the rapid response team wasn't.
Nurse Mancuso is an expert. I'm saying the record evidence, what this hospital, which doctors were on the rapid response team?
In all candor, Your Honor, the team wasn't called, so I can't give you the names. I can tell you that Nurse Mancuso said an anesthesiologist, a critical care doctor would typically be on the team. I think she referred to, I think she referred, she didn't say typically.
You're asking discovery? Did you submit a discovery, an interrogatory, or just saying who was on this team? What were the specialists? Have they ever had this problem before? What is the success rate? What if Dr. Reyes was on the team?
Well, Dr. Reyes is a hospitalist. He's not an intensivist. He's not a critical care.
What if, I mean, that's my point. We don't know.
Yeah. I know, but what we do know is that there was no rapid response called, in all candor, with the court. And we do know that Dr. Salzman said an hour before, if an NG tube was inserted, Donald Koskovich would have survived.
Is
And we
there
do
any
know-
evidence in the record that one of these critical care people on this team would have ordered the NG tube? Do we have anything that says, you know what, we know, or we at least have evidence to say that had the rapid response team been called, one of these people, and admittedly, we don't know even who was on the team, but that one of them would have ordered it?
We do know, Your Honor, that Nurse Mancuso says or testified that an intensivist, a critical care doctor, would be on the team. And we do know from Dr. Salzman, as an intensivist, a critical care doctor, if, you know, an hour before the NG tube would have been inserted before the code, the man would have survived. That's what we have, Your Honor, in all candor with the court.
Is there even a hospital policy in the record? I was trying to find what the rapid response, I mean, Mancuso and Salzman are expert witnesses. They testify as to the record evidence and they opine. They don't say, you know, generally the practice among 50 states. And so I'm going to get there, and I understand the importance of an expert, but I need to know some very basic facts. What is the practice and procedure of the hospital for this rapid response? Who is on that team that day? What do they typically call for? What is their success rate?
That's not in the record, Your Honor. That's not in the record. That's why the easier analysis, to be frank with Your Honors, is the loss of chance doctrine. And that's why this man was screaming out for help, so to speak. He deserved the chance to survive. He deserved the rapid response team to be called. And if called at an appropriate time, the team of physicians at bedside could have and would have at least contemplated, if not gone forward with an NG tube. This man had a small bowel ileus.
So if I can, your lost chance then is 245. You're saying
that's the last one. That's the last window, Your Honor. Thank you.
Right, and so that's your lost chance. So what evidence is in the record that if she had called this team, that they would have ordered the NG tube? What evidence is there?
The only evidence in the record, which goes with the loss of chance doctrine, is on a rapid response team includes an intensivist, critical care doctor. Dr. Salzman's a critical care doctor. Dr. Salzman says if an NG tube was ordered, based on his experience and training, the man would have survived. So that is certainly enough. I'm sorry, go ahead.
That any critical care person or doctor is going to order an NG tube, or just is it in hindsight, if it had been put in then, as opposed to it had to have been, it should have been put in then?
No, I think if you look at the loss of chance doctrine, it's not a matter of hindsight. It's a matter of whether a jury, fact, could reasonably infer, okay, under the loss of chance doctrine and the cases in Section 323, could reasonably infer that if a critical care doctor is called, such as a Dr. Salzman, and pursuant to a rapid response, that an NG tube would have been inserted because of the small bowel ileus, the obstruction, and the gastric contents, at least in part, that had been, for lack of a better word, vomited up earlier in the day.
Okay, and so you know, counsel, you're at 6 minutes and 40 seconds.
So Mr. Victor, I apologize for monopolizing the time, and if the other judges want to jump in. Let's move to the loss of chance doctrine. I don't very much understand Thompson. It's sort of above me, but I read it, and I read it a few times, and
okay, you're freezing for a second.
Hello?
Yes, you're freezing for a second. I'm sorry.
So moving to Thompson, we have this, it seems to me the key word is interruption. And so if you don't want to say that's a verb or whatever, but it was a patient at one hospital transferred to second hospital, which delayed a surgery, which resulted in tragic consequences. So the interruption, the act, would have been, I think, sending the patient to a second hospital just because they didn't have money. What is the interruption? Would the rapid response team have spontaneously arrived if it wasn't for the nurse calling the hospitalist physician? And when does she interrupt this process?
She failed to get emergent bedside nursing or bedside physician team to his bed when he is rapidly deteriorating. Okay, and if you look at the language in Thompson, if I may quote it, it says in part, even if the evidence permits only a finding that the defendant's negligence increased the risk of harm, that's all we have to show is that the negligence increased the risk of harm or deprived the plaintiff of some significant chance of survival or better recovery. It is left for the jury to decide whether there is a probability that the defendant's negligence was a cause of the injury.
Right, and I'm not even so much going to that. I want to talk Thompson, and the facts of Thompson. You're right, loss of chance doctrine. I want you to explain where the interruption, and I can also read a quote from that in that case the medical practitioner undertook to protect the patient from a particular harm and negligently interrupted the chain of events. So in my mind, here that would be the rapid response team would have been called, but this nurse interrupted, to use the words, the chain of events by, we could brainstorm, but I'm asking you, where is the interruption here?
Well, I think that's a good question. I think failure to call is synonymous with an interruption to get a team of experts to his bedside. It's synonymous. Failure to activate or failure to call a rapid response is the same thing as interrupting a team to come to his bedside and brainstorm what this man needs so he doesn't continue to go downhill and go into a code.
Well, I want you to be able to reserve. So.
Okay. May I say one thing more? Okay, because I'm short on time. If you look at the language in Thompson, it says we believe the restatement rule evidently followed by the trial judge here to be the better rule adopted by the Court of Appeals in Heiser. We acknowledge it permits the case to go to the jury on the issue of causation with less definitive evidence of probability than ordinary tort case. To the extent, no doubt, it permits the jury to engage in some speculation with regards to cause and effect. Okay, I'll reserve the balance. Thank you.
All right, and counsel, you have 2 minutes and 39 seconds remaining then. Give me just a second, Ms. Jankaitis, because I need to reset the clock. All right, when you're ready.
Thank you, Your Honors. Kelly Jankaitis, and I do have Megan Gailey with me. We're here on behalf of Scottsdale Healthcare Hospitals, now known as Honor Health. And we ask the court to affirm the judgment of the Superior Court.
If I could interrupt for a second. Mr. Victor, if you could please mute yourself.
Thank you, Your Honor. I think your questions are really great because they highlight what the actual issue on this appeal is, and that is that there is just no evidence of causation between the nursing negligence and the harm that's alleged here. Whether the court applies a direct causation standard or an increased risk of harm a la Thompson, both of those require some sort of expert evidence. Mr. Victor had indicated that it was easier to apply the loss of chance than it is to undertake the analysis that somebody was suggesting. But the analysis is the same. In a normal medical malpractice case, there has to be expert evidence of causation. Under the Thompson standard, there still has to be expert evidence. It's phrased a little differently.
So, Ms. Jankaitis, let me ask you a question then. You seem to, in your answering brief, concede that Thompson applies. Is that accurate?
I do think that we agree that this is a loss of chance case once the dust settled, and that's how plaintiff ended up arguing it, yes.
Okay, so that language in Thompson about the negligent interruption, and if you think of that as a policy that sort of weaves through the case to lower the burden, the interruption is not required. This applies to any case in which, I mean, it sounds like something was just not done. That is negligently interrupting a course.
That's my reading of Thompson, is that it has a broader application to when the plaintiff is alleging a increased risk that results from an act of alleged negligence. And then that creates a two-part test that we
Counsel, can I interrupt you for a second there? Before you move on, you mentioned that expert testimony is required, obviously, for more of the regular med mal cases, and then also for under the loss of chance doctrine or theory. What specific authority, if you know, supports or says in black and white that you do have to provide expert testimony or to show that there's an increased risk of harm?
So I don't think there's any direct authority in the Thompson context that says that, and it's just general medical malpractice principles when a common lay person can't form that causation link on their own. And in a case where you're talking about an increased risk of harm, that by its nature is something that would be difficult for a lay person to connect the dots. As your questions kind of demonstrate from earlier, as to what actually would have happened if a rapid response had been called and how that actually affects the patient's care and the reaction of the various participants in his care and how it ultimately affects or increases the risk of harm.
Ms. Giancakis, let me get back to the causation inquiry with you as well, because even just as you said it now, you framed it as either calling the rapid response or this nurse doing nothing at all. Is that the issue? Is that the causation issue?
I'm not the best participant to answer this, since we're kind of at the whim of the plaintiff's theory, but my understanding is that the alleged negligence is that the nursing staff did not initiate a rapid response soon enough.
And so we don't account for the real world, what happened. We just say rapid response or nothing at all when determining causation.
Well, I believe that we do need to account for the real world, and that is part of the problem with this case, and that's what's missing from the evidence here. The evidence basically is an expert opinion that the nurses were negligent in not elevating the level of care. The doctors were negligent in not identifying an issue and placing an NG tube or ordering that Mr. Koskovich be placed on NPO status. And the only causation expert says that if the doctors had given the NPO order or placed the NG tube, then Mr. Koskovich would not have died. What's missing here is any link between the failure to call the rapid response and the increased risk of injury.
Is that tied, and this is what I was trying to understand, is there something in the record that shows from I assume their expert that says this critical care doctor would have ordered that at that time?
No.
Or who was?
So that's isn't that a missing link? That without that, we can't. There's nothing for the jury to get there.
That's exactly right, Your Honor. And on this record, I think it's unlikely that anyone would say that the response or the separate statement of facts to the MSJ contains medical records that show that this patient was seen by multiple doctors that day. He was examined. I'm not a medical malpractice litigator, so my understanding of the science is very basic, but they examined his abdomen and did not find anything that was urgent, treated him for dehydration, and it looked like some preemptive infection actions while they took an x-ray. And then he was seen by another doctor a half an hour before he coded, and there's no indication in the record that they observed anything that was wrong or that they thought he needed to be on NPO status or have an NG tube placed. And there's no evidence, there's no expert testimony indicating, as you flushed out in your questions, what a rapid response team would have done.
Well, I think there is. I mean, there's an expert who testifies generally to rapid response. But what I'm saying is, in the facts of this case, I mean, we're dealing with a specific case with real tragedy and real people. And where in the record do I see even the hospital policy on rapid response? And then we can talk about the team and how talented they were and whether they were former hospitalist physicians, and we could talk about causation on that front. But where is that in the record, the policy? Let's begin with the rapid response policy.
No, there's nothing in the record that actually indicates what would have happened if a rapid response would have been called, who would have come, what they would have done, how that would have actually affected the care that was given to this patient. I think that there's some...
Isn't the absence of an expert on that the flaw? Again, coming back to that, we don't, well, the jury may even in these cases have some leeway. They have to have at least some jumping off point. And we don't have that, do we?
Exactly. The Thompson test is two parts. The first one requires expert testimony. In this case, this judge determined that they needed expert testimony of the possibility of harm, and that finding's entitled to deference. And then the jury is allowed to infer a probability of harm, but they have to have that expert information about possibility of harm to make that inference. And the cases that the appellant cites in his brief really highlight what's missing here in the Adventist healthcare case, which is out of Maryland, and I'm not sure it exactly applies to the same standard that we're looking at here, but this was a case where a gentleman underwent a colostomy, and the plaintiff alleged that the nurse should have called a rapid response team by a certain time. There was testimony that laid out what would have happened if she had called rapid response. They would have alerted a doctor. There's a doctor on call all the time. That doctor is prepared to do surgery within X amount of minutes. He could have called an x-ray in on the way, and he'd done an exam, and the operation would have started by this time. And if the operation had started by this time, it's likely he wouldn't have died. Or I think...
Okay, so let me ask you a question on Adventist. Why would it apply? Let me tell you what Adventist was. This is a quote. After a physician failed to answer the phone calls of a nurse, okay, hard stop, and then we can continue. The rapid response team should have been alerted. Here, a hospitalist physician was at the nurse's elbow, or certainly responded. So how do we get to Adventist?
Well, I don't think that it applies, but if it does, it's distinguishable because they have the link between the nursing negligence and what actually happened to the patient. Here, there is no evidence and no link as to what would have happened if the nurse had done what the plaintiff thinks they should have done. The rapid response is explained generally in the testimony, and it definitely sounds like something would have happened, and it sounds intense that something would have happened, but would it have prompted the doctors to identify the issue with this gentleman and place the NG tube that was needed to save his life? I don't know. And a juror isn't going to know either.
To acknowledge, I don't think it's fair to say there's no, there's an expert here that the plaintiff retained that speaks about rapid response teams generally. So I mean, again, that I don't want to just sort of say that's not in the record, because that is in the record. Why isn't that enough?
It's really general information that does not link the rapid response to the need for an actual placement of the NG tube. And you can't win summary judgments on speculation. I mean, what the plaintiff actually needs is some expert that says it's possible that had the nurse initiated a rapid response at a certain time, the plaintiff would have gotten the NG tube and lived. That evidence is not in the record.
Now, I kind of come back to, and that's the jumping off point. It's possible they would have gotten it, then it's up to the jury to decide the probability from that. But the possibility language isn't there in, and I certainly expect Mr. Victor will tell us if he thinks it is. Where is the possibility language that the jury can jump then to probability? Your perspective, it's not there.
That's exactly my perspective, Your Honor. Thank you.
You are at 7.5 minutes. If I don't know if there's anything more you had, counsel.
I just looking through my notes really quickly. The only other thing I think that I wanted to point out was that in the reply brief, appellant points out the summary judgment standard about inferences having to be drawn in favor of the non-moving party, which is true, and says that it must be assumed based on the testimony and evidence that absent nursing negligence, a rapid response would have immediately brought a competent team of trained emergency doctors to Mr. Koskovich's bedside, who would have correctly assessed his dire medical condition, known what to do, and would have timely treated him and saved his life. That is an assumption, and it's not supported by the record. And yes, you have to construe inferences from the evidence in favor of the non-moving party, but you can't assume, the court can't assume that evidence exists or make inferences out of nothing. What the actual evidence is that there was some negligence and Mr. Koskovich passed away, and there's no link that would help a jury of unsophisticated lay people understand how what the nurse did actually affected this patient under these circumstances. Happy to answer any other.
Well, I mean, I just want to make, and I know this isn't necessarily relevant, but there, as you know, there are other parts of this case that are going forward.
Yes.
Okay.
All right. Thank you, Your Honors.
Thank you. Counsel, give me a moment to reset. But while I'm doing that, and I don't want to cut off my colleagues, but if you could just tell me, based on my last question, where in the record I do find that jumping off point.
Your Honor, I don't think you need a jumping off point or magic words that need to be uttered. I think it's a reasonable inference that the jury on a loss of chance case can take from Nurse Mancuso's testimony to Dr. Salzman's testimony. Nurse Mancuso said if the patient is allowed.
Counsel, are you conceding that there isn't that jumping off point, that link that we were talking about?
I'm conceding that the magic word of possibility is not necessarily uttered with regards to the NG tube being possibly inserted. But we're dealing with a loss of chance. A loss of chance is strictly that under Section 323 of the Restatement of Torts. He is entitled to that chance. He is entitled to that possible opportunity. And he did not get that chance, okay? He deserved that chance. And that's what the loss of chance cases talk about. And Nurse Mancuso said, you know, if you're going to let him get to the point where he codes, he's got a 17 to 20% chance of survival. And that's the thing. You do not let the patient get that far to where they code. You call in the rapid response.
How did the nurse let? The nurse called a hospitalist physician.
Because she did not, she failed. This goes back to your earlier inquiry. She failed to call the rapid response team. The Dr. Reyes at 11 o'clock, 2:45, that's 3 hours and 45 minutes. And what does the nurse do? She goes to lunch at 3:30. And while the patient is rapidly deteriorating and decompensating, he lost the opportunity. It's a very straightforward case. How are you going to save somebody in a hospital setting who is rapidly deteriorating if you don't call a rapid response team? If you call a rapid,
and that's not even before us, right? Standard of care. So you don't have to worry about. I mean, let's get to What's
No,
in the
but
record?
It goes to the loss of chance, in all due respect. If you don't call the rapid response team, he doesn't get the chance to survive. He doesn't get the opportunity to have the critical care doctor come to his bedside with other professionals. Nobody gets to brainstorm. Nobody gets to decide about the NG tube. He lost that opportunity.
Does loss of chance mean don't take discovery on it, and then there might be a chance because it's still unknown? I mean,
No.
You took no discovery on it.
That's, in all due respect, Your Honor, that's not the issue. The issue is he deserved the chance, and he didn't get the chance, and he passed away. And the jury can reasonably infer that that chance, that opportunity, could have helped him. Okay, and that's what the loss of chance doctrine focuses on. You look at the Silica case, and it talks about the same thing. The bottom line is, Your Honor, several times in the oral argument in the lower court, 6 times no less, Ms. Galey said, this is not a loss of chance case. And she said, that's a different beast, okay? And Judge Campanella on page 39 of his, oral argument says, based on the expert, the report of Dr. Salzman in his testimony, I don't find that there was a prima facie evidence of causation, that the nurse's failure to order a rapid response team was the cause of Mr. Koskovich's death. That totally is different than looking at the second rule. There's the first rule, okay, cause and fact. There's the second rule under the loss of chance theory, that whether or not that lost opportunity increased the person's chance to have significant injuries or death. And the jury can reasonably infer that from all the cases that I put forth in both briefs, Your Honor. Thank you.
All right. Thank you, counsel. We will take the matter under advisement. We appreciate your thoughtful discussion and argument here today, and we'll issue our ruling in due course.
Thank you.
We have another oral argument, so we're going to go ahead and disconnect at this point.
Thank you.
Thank you.